United States Court of Appeals for the Fifth Circuit is now open according to law. God save the United States and this honorable court.
Good afternoon. Our first case for today is 2020-20389, Lndmrk Amer Ins versus SCD Mem Pl II, LLC. Mr. Brown, you may proceed.
Thank you. May it please the court. I'm Jay Brown here on behalf of the appellant, Lndmrk Amer Ins. SCD has not met its burden to show that the damage was directly caused by a specified named peril. And that's critically important here because the Lndmrk policy is a named peril policy. The peril that caused the damage here is flood, and flood is not named in the Lndmrk policy. To illustrate the Lndmrk policy, I'd like to compare it very briefly with the only other policy in the record here. The Lndmrk deductible buyback policy is a creature of an entirely different species from the Lexington policy, which is an all-risk policy that specifically includes flood. The Lexington policy is a primary policy, multiple locations, multiple states, $167 million in limits. The Lndmrk policy, on the other hand, is a named perils policy. It is not all risk. It has completely different terms. It's only for this location. And then it's only for two narrowly defined perils, windstorm or hail, and only for windstorm or hail associated with the named storm. It was not issued, as the evidence shows, to insure all the perils within the deductible of the Lexington policy, but only for windstorm or hail associated with the named storm.
Brown, where in the policy are perils in occurrence defined, if anywhere?
Yes, Your Honor, they are, and they are defined differently and distinctly. The concept of occurrence is defined in the Lndmrk definition of loss, and it says loss shall mean a loss or series of losses arising out of one event or occurrence. The concept of perils is, and if I may, let me get to the concept of perils through the insuring clause, if I might.
But are there discrete, like unmistakable definitions?
Yes,
in the policy of perils and occurrence.
The perils in the policy are identified in item 3 of the schedule, and it says perils covered, windstorm or hail associated with a named storm. And our position is that the words windstorm or hail associated with have meaning, and that the district court, in our briefs, it's clear that the district court disregarded the meaning from those words, and that named storm here is clearly the occurrence, and the perils are windstorm or hail associated with that occurrence. And that is clear in the language of the Lndmrk policy. It is particularly clear. It begins with the insuring clause. And unlike a policy that has an all risk clause, this policy says it will indemnify the insured in respect of direct physical loss or damage caused by any of such perils as are set forth in item 3. Just a moment on the word direct. It has a special meaning given to it under Texas law that's different from Louisiana law, which I'm no expert on. But direct physical loss, when used in an insurance policy under Texas law, requires the loss to be immediate or proximate without an intervening cause. And that's different from just caused by. Direct physical loss, in quotes, does not mean the same as, quote, physical loss in insurance policies under Texas law. We provided that to you. So with that in mind, the insuring clause says in respect of direct physical loss or damage caused by any of the such perils as are set forth in item 3, we go to item 3, and item 3 says perils covered, windstorm or hail associated with the named storm. This court made this very same I'm sorry, beg your pardon?
I have a quick question, just practically speaking. How does this work? And perhaps I should know this already. If the wind, we normally think of hurricanes as involving both flooding and wind and related wind to flooding. And I think that the district court obviously kind of grouped those together as being part of the normal circumstances of a hurricane. How does this work whenever the roof is blown off and then the facility, the building fills up with water?
Yes, Your Honor. As a starter here, there's no evidence at all that happened. But if the roof is blown off, the direct cause of that was wind. It doesn't get blown off from flood. And most of these when that happens, the rain enters from the wind damage and typically it's covered. Here, as far as how it works, it's interesting because a deductible buyback policy is, first of all, it's a bit misnamed, but it's a policy that comes into place after this, what I'll call massive insurance program is already in place. And an insured wants to insure against specific perils for a location. And that is this as shown with an affidavit that we've submitted from the underwriter, from Josh Gibbs, the underwriter. He went through and he considered different perils.
Wasn't that not used?
Well, it was certainly, that's a very good question. It was certainly never addressed by the district court and never commented upon. It was submitted, it was never objected to, and it is within the record. It is uncontroverted. And it was not admitted, as SCD would say, to vary the terms of the contract. It's not admitted for that at all. It's admitted in keeping with the teachings of Texas law that you can admit an affidavit to show the business context under which a contract was entered into. And it was also admitted for the legal principle that there was different dollars charged for different risks, and there were no dollars charged for flood. And so therefore, in the unlikely event this court were to interpret this as somehow covering flood, there's been no consideration paid for that peril. But let me point out that the way that we're urging this policy work is exactly the way the court said the policy should work, exactly the way this court said the policy should work in the Six Flags versus Westchester case. And in that case, in our material, this court also distinguished between the occurrence and the peril. And the court said that the occurrence does not equal the peril. The peril is the cause of the loss, and the occurrence is not the cause. Judge Rosenthal, in dealing with a claim involving the Alley Theater, cited to Six Flags versus Westchester and explained it also. And she explained that occurrence is a distinct concept from the peril. And I think what happened with Magistrate Stacy is that it came off the tracks when the concept of peril and the concept of occurrence became conflated. Now, that's not to say, and bearing in mind the Texas Supreme Court teachings and noting that Judge Willett was on the FICE panel, and the court then cautioned us, and this court has cautioned us, that we must construe insurance policies one policy at a time. And with that warning in mind, I'll note that other policies may define a named storm as a peril, and that's okay. They can do that. We want to give all the words meaning, but this policy does not. This policy is a named peril policy, and under the case law of this court and Texas courts, this court has commented on what named peril policies are. This court addressed this in the Courtroom case. In the Courtroom case, there was a question of the loss of contents in a house, and they would only be covered if the insured proved they were damaged by the named peril of wind, not by flood.
That brings me to another question. What is your response to opposing counsel's argument that your definition of windstorm ignores the storm part of the word? And it sounds like you were trying to recast it as wind damage, which the last sentence you said was using that term.
Well, no, I recognize the point. There obviously has to be damage, as we all know, to even make a claim. But the windstorm definition, it's very thoughtful, I believe, how the landmark policy, which is only going to be called to respond if there is a claim, adopts the very definition of windstorm from the Lexington policy. And windstorm is, or adopts the very definition of named storm from the Lexington policy. Named storm is defined in the Lexington policy as whatever the National Weather Service says it is. And that's important to know exactly what a named storm is. And for those of us that suffered through the weather in Texas 2 weeks ago, it was horrible. We heard about it. We lived through it. And I was a little bit chagrined that the National Weather Service did not declare it to be a named storm. The Weather Channel did. So it's important how things get to be defined. And to recap, the landmark policy goes to the definitions of named storm, and that's in parentheses. And it just says a hurricane, typhoon, or such that's defined, that's named by the National Weather Service. As far as the wind part of that, this court commented on what wind is in the Kemp case. The Kemp case from this court identified windstorm. And the Kemp case relied upon Texas cases to identify windstorm. And it's our position that if the district court said, well, we don't know what the definition of windstorm is. Well, this court has defined windstorm for us in the Kemp case. And windstorm was defined in the Kemp case. Basically, a windstorm must be taken to be a wind of sufficient violence to be capable of damaging insured property. And Texas courts have also defined windstorm. Texas courts, the Weatherman case, is cited by this court and by Texas courts as having the definition of windstorm under Texas law. And that wording should be familiar because it came right out of the Weatherman case. So rather than have this term rendered meaningless, I would urge that windstorm be interpreted with the precedent provided from this court and from Texas law. Now,
Mr. Brown,
windstorm.
Mr. Brown, tell me to what degree is the Pan Am Equities case relevant? Of course, it was a different contract term. It was a different type of policy. I mean, the guidance may be limited, but how does it help you if it does?
I think the Pan Am, and I'll note that the Pan Am case was very different on its facts, but it really helps us distinguish between the importance of peril on the one hand and occurrence on the other hand. If I may, let me delve into Pan Am. In Pan Am, like here, the event, the occurrence was Hurricane Harvey. Again, the peril that caused the damage, though, was flood, just as here. Pan Am does not involve the question of whether the loss was covered or even the question of what peril caused the loss, because as here, flood caused the loss. The Pan Am policy was an all-risk policy, not a named perils policy as in here. But in Pan Am, it's instructive because the court had to identify and distinguish between the perils in order to know which deductible applies, because the deductibles aggregated the damages from different perils into different deductibles. And it's interesting, the Pan Am illustrates that there's a difference between the occurrence and all the many perils associated with the occurrence. And specifically, the Pan Am case used this language. It said that named storm deductible provisions, quote, sweep in a slew of associated perils explicitly untethered from wind, comma, specifically flood. And that's exactly what happens here. Yes, when there's a hurricane, there are many different perils involved. Those perils are insured by an all-risk policy. are they insured by a named peril policy? We have to look at the definition of perils insured. And this court teaches, as well as the Texas Supreme Court, that, and I like the language in the Pan Am course, in the Pan Am case, it said, Justice Willett writing, that Texas law commands that we honor the policy's plain language, every word on every page, giving effect to all the policy provisions. And here, the motherboard of this policy, every claim that comes in, every consideration for a named peril policy has to go through the insuring clause and the named perils provision. And here, the named perils provision, it doesn't say earthquake, it doesn't say fire, it doesn't say named storm. It says windstorm or hail associated with a named storm.
Mr.
And so,
Burke, you haven't discussed Mr. Miller's argument, at least I'm not sure that you've discussed it, that the Lexington policy definition of flood, wind gusts, etc., was incorporated into the windstorm that was due to a named storm, when you have a named storm. Can you just deal with whether or not that those words are used?
no, they're not. I'm not quite sure. I apologize. I'm not sure I understand the question. The named storm phrase is embedded within the deductible provision, but it's just, that's the place where it's defined in the policy. And what it says is, it says named storm, and then there's a parentheses, and it gives the definition and then another parentheses. And it basically said within those parentheses is a hurricane, a typhoon, a tropical storm that's identified by the National Weather Service as a named storm. It doesn't.
No, I'm not talking about the named storm definition. I'm talking about the windstorm definition.
Okay.
That if it's a named storm, you look to the windstorm definition of the Lexington policy, of the Lexington definition. If you don't, I know that you believe you don't, but can you explain to us why you don't believe we should look at that?
Okay, I think there's none of the policies define windstorm. First of all, this court defines windstorm in the cases provided. Now, it's interesting that the Lexington policy does define named windstorm. It has a separate definition for named windstorm. And
okay, if your position is nobody defines it, then that's the answer to my question, and you've used your time. So you save time for rebuttal.
Okay, I didn't realize my time with that. I'd like to address that further if the court doesn't feel like, because I'm not quite sure I understood it, but I'll listen. Thank you.
Okay, well, maybe Mr. Miller will clarify it for us, and then you can address it on rebuttal. Thank you very much. Or maybe he won't, and you won't feel the need to. But thank you very much. Mr. Miller.
Thank you. Mark Miller on behalf of the defendant, appellee, SCD Memorial Place II, LLC. I want to do three things here that I think would help. One is I want to discuss the two policies and how they fit
according
together.
to law.
They fit together.
God save the United States and this honorable court.
I'd like to talk about
Good
the
afternoon.
precedent this court has made with the various
Thank you
other
for
cases that
attending
dealt with
this
different
Zoom
policies.
hearing. I am
and
very
how
sorry
A ruling here
that we
does
weren't
not
able to
disturb
accommodate you
any of
in New
those
Orleans
rulings.
this week.
And
As it
three, I'd like
turns
to
out,
bring in some
one
public
panel
policy
of our court is having some arguments,
consideration.
but
We've been in this for years, and we've spent
since
a
you
lot
were
of
the
money.
only
And
panel
we think
on
the
which
contract
both
language is
attorneys
pretty clear, and we don't
signaled
think
your
that
willingness to
parties should
show
be
up,
submitting affidavits
we
that
didn't
could
think it made
fill in the
sense for us
percentages
all
of
to
what they
troop
thought
down
the
there
policy
for
was.
that purpose.
So how do
But
these
things are
policies
going to
fit
change
together?
pretty
I
soon,
think
I
this is
think.
critically
So
important.
that's something.
SCD Memorial
We do
Place
have a
II
couple of
is
adjustments
a
or
building. They own a building in
extra
West
rules of
Houston.
the road
It was impacted
for
by
purposes
a
of Zoom
hurricane.
hearings.
Now, they're
One is
part
we
of
ask you to
Skanska.
silence
Skanska is an
any other
international
devices you
developer,
have
and they develop
or those
throughout the
of
United
people in the
States, and they
room
brought a
with
master
you.
policy. And this
Second one is
important.
that
It's not
we
a throwaway. The
still
master
do
policy
the audio recordings
starts the discussion
of the
for us.
sitting,
The
but
master
we will
policy
not,
has
we
two
do,
deductibles, and we saw
as
this
in New
Pan Am.
Orleans, you're not
It's
allowed to
actually
video or audio
Pan Am
them
Equity's
for
decision.
yourself.
It's actually the exact same
If you
policy.
like, we
The
will
master
give
policy has two
you
deductibles.
5
There's a big
minutes
one,
uninterrupted
small one.
time at the beginning
small
of your
one's for flood,
presentation,
$50,000.
just
And the
because
big ones
there's
for-
always a little bit of a
for
gap in
windstorm or hail. And I'm
communication
gonna say,
here. And
open
then
quote, windstorm
the other
or
thing I
hail,
would
close
say is
quote.
we will
It's
appreciate
the heading
both
for
of
that
your cases,
deductible
record
provision.
citations.
The heading for the deductible provision.
We have a
windstorm
time
or
clock
hail,
system. The yellow
says
light
what that
will
deductible is. It's
tell you that you have
2.5%
2
of
minutes
total
left, and
insurable
when the
value.
red light
That's a big
signals,
number.
we ask
The
you to
building's worth
conclude unless you're answering a question from the
71
court.
million. So the
The
deductible
sole
on that is
case this
1.7775
afternoon is number
million.
220416,
We did what
Polyflow versus
Pan Am
Specialty
Equities didn't do.
RTP.
We
And
went
we'll
out
hear
to the
from
market
Mrs.
to
Stratton
say,
to
hey,
begin.
can we buy deductible?
Thank you, Judge
buyback
Jones, and may it
insurance?
please
And
the
answer is
court.
yes, you can buy it.
The parties' contract says that any
If you look
action
at the first
arising
page
out of the
of the
agreement
Landmark
must be
policy,
arbitrated.
which is the policy at
In
issue
this
here,
action,
it says
Polyflow
deductible
alleges that
buyback
appellees
schedule.
breached
Throughout
the
this, it
agreement,
buys back
giving
the
rise to
deductible.
various contract and
Just
tort
plain
claims.
reading.
But
We're
the
buying
district
back
court
the
denied
deductible. What
Polyflow's
deductible
arbitration
are we buying
request.
back? It says
This court
perils
should
covered,
reverse for two
windstorm,
reasons.
or
First,
hail
because the
associated with
parties
the named storm.
undisputably
And it's
have an
got
arbitration
two
agreement,
asterisks.
the law
Following the
heavily
named storm
presumes that
definition
Polyflow's
in
action
Lexington
is
Insurance
arbitrable.
Company policy.
To deny
So
arbitration,
what do we have here?
this
We
court
have
must have positive
windstorm or hail.
assurance that the arbitration
didn't come out of
agreement
nowhere.
cannot be
It was
read to
track
cover
the
this action.
deductible provision.
There is at
So it's
least
a
no such
deductible
positive
buy-down
assurance here.
insurance. The landmark
Second,
policy
appellee's
throughout the
merits
policy says
defenses
that
and
incorporates all the
procedural
terms of the
arbitrability
Lexington
challenge
policy.
are for the
So
arbitrator
we
to
went
decide,
beyond what any other
and thus
policy
may
holder has
not
done,
preclude
and
arbitration.
as reviewed by the circuit.
To begin,
we
the
did
scope
beyond
of the
what Pan Am
arbitration
did. We
agreement
went
here
out
is
and bought the
reasonably
deductible
construed to
buy-down
cover this
policy
entire
for what
action.
deductible?
The settlement
Windstorm
agreement
or
requires
hail.
arbitration of any
And that
action
is
that
the peril
arises
covered,
out of the
windstorm or
agreement.
hail.
The plain
Now,
meaning of
we think that's a
action is
simple issue.
lawsuit, the
It's
entire
simple,
civil
based on
proceeding.
policy language.
So the parties agreed to
and it's simple based on the
arbitrate
numbers.
the entire
First,
civil
policy
proceeding if it
language.
arises out of the
Well, I've been
settlement
through that.
agreement.
It's
And this
windstorm or hail
lawsuit
has
qualifies.
meaning is from the
First,
Lex-
this
Lexington
lawsuit
master
exists
policy.
because of the
Well, let's
settlement
look at the
agreement.
numbers.
And the first page of
And
Polyflow's
by that,
complaint
The limits
at
of the policy
1189
are
of the record on appeal makes that clear,
1,573,500.
stating that Polyflow is bringing
You
this
add on
action
that the
because the parties entered a
$250,000
settlement agreement,
deductible in the
but
landmark
appellees have
policy,
not complied
and you
with
get
it
the exact
and never
same
intended
number
to comply.
That is 2.5%.
Second, this
of the
lawsuit
building value,
includes claims that
77.1
appellees
million.
concede arise
we were
out of the
fine.
agreement.
Isn't it possible
Specifically,
that you could have bought a
Polyflow's
policy
claim and
that
appellee's
has a
counterclaim
definition of
for breach of the
windstorm
agreement.
that is incongruous
So because
with
this
the
action
master
unequivocally
policy,
includes claims that arise
so
out of the
that
settlement
you
agreement,
didn't get
and
the
indeed,
coverage that
the
you thought
lawsuit
you were
only
getting,
exists
but maybe
because there
that's
is
for
a
another
settlement
day
agreement
with a
that we
broker
allege
or
has been
something, but
breached.
not
The action arises
No,
out of the
we did
agreement.
because that's what
And
you
the plain
sought
language of
doesn't
the
mean that's
arbitration
what you
clause
got.
thus
Well, I
requires
think it is what we got
arbitration
because they
of the
used
entire
phrase
lawsuit.
windstorm or hail.
And this
the
court
phrase windstorm or
employed
hail and
that
the
reasoning
deductible
in its
buyback
2019
schedule
decision
is
in Archer, which we
what's
cited
used
to the
in
court
the
as
main
supplemental
policy.
authority.
And it uses the
The
exact
Archer
same phrase,
panel
windstorm
focused
or hail.
on the plain
And it's
meaning of the
defined to
term
include
action,
everything a storm
which meant the
includes.
entire lawsuit,
Okay, is
not
it
just
ever defined to
individually
include
qualifying
flood,
claims.
wind gusts,
And it
storm surges,
refused to
tornadoes,
rewrite the
cyclones, hail, and
arbitration
rain?
agreement there to
Is-
encompass
is
only
windstorm or
individually
hail
qualifying
defined
claims.
as
Is
that?
windstorm ever
And
to
I think it's
include that?
important to
Ever
note
define that?
that
Well,
the reasoning that Archer used
is it ever
applies
defined?
with even
No,
more
windstorm or hail
force
is
in
not
this
defined.
case,
It's
because
not
there,
defined.
Archer
But it is
involves an
So-
exclusion
If-
from
Well,
arbitration.
then why would it
So the
list
plain
hail
meaning of
separately?
action, the exclusionary
If
language, had to be
windstorm
enough to
includes hail,
overcome
no,
a
and the other
presumption in
policy would
favor of
include that,
arbitration.
Then why is it listed
Here,
separately?
the plain meaning of
I
any
asked myself
action
that
governs what
because
is
I said,
included in
windstorm is one
arbitration.
thing,
So
but
in
why
this
does it say
case,
or hail?
the contract's
And I kept
plain language and the
scratching my head
presumption in
thinking about it.
favor of
And the
arbitration
answer is this.
are rowing
It's
in the
because
same
it tracks
direction.
the language exactly in
Now,
the master policy.
Appellees
If
have
you look at the
contended
heading,
that the
it's
settlement
windstorm or
agreement
hail.
deviates
That's what it's
from the plain
tracking.
meaning of
It's
action
tracking that
and
language.
specially defines
Windstorm or
action
hail
to
in
more
one
narrowly
policy
mean
is
only
tracking the
claim.
windstorm or
But the
hail in the other
contract
policy.
does not
It's sort of,
support that argument.
I wouldn't call it a
You
term
can see
of
the
art, but
settlement
it's
agreement at
referencing
tab
other
4
policy
of
then?
our record excerpts. And
Does
if you
your
look in
case
subsection
rely
A
upon
on the very
reading the
first
maintenance
page,
of
you'll
primary
see that the
insurance
settlement agreement does
section
not
of the
define
Landmark
the term
policy to
action.
mean that it intends
So
to
under
import
ordinary
the windstorm
contract interpretation
deductible from the
principles, the
Lexington
plain
policy.
language of the term should govern lawsuit,
Let me try to
entire civil
understand, Donna.
proceeding.
I'm not,
What the
I'm not sure
settlement
I
agreement
understand.
does
Did Le-
define
the
at
question, did
A1
Lexington do
is the
wrong
term
thing
claim.
by
And it
applying the
defines it because
2.5%
it's going to
deductible?
use that term to
Or am I reading the
describe what is
question
being
No,
released by the
how
parties
do you
in this settlement
decide
agreement and released.
whether or
So
not
it defines
imported
claim
the
expansively
windstorm
to include
deductible
not only claims, but
language?
also demands, actions,
saying it
causes of
does,
action,
it
so on
must?
and so
I mean,
forth.
it's that
All that this
normal
means,
business
however,
person
is that
reads it,
when the settlement
one
agreement
policy
uses
says
the
it
word
covers
claim,
windstorm
it
or
means
hail,
to
it covers the
incorporate a more
deductible.
expansive
It's a
meaning.
deductible
It does
buyback,
not
and
mean
the
that when the
deductible that's
settlement
buying
agreement
back
uses
is
the word action, as
windstorm
it
or
does
hail,
in this
and it's
arbitration agreement,
defined to
that
say
the
what it
parties
includes in
intended
this
to more narrowly
scenario.
constrict the plain meaning of that
Okay,
term
what do you
to
do
mean
with the
only
fact that
claim.
their
And
argument
in fact,
is
Your
that this
Honors,
is not a windstorm?
A1 of the settlement agreement that
It's
defines
just a
claim
basic
shows the
argument.
parties understood that there is a difference
Well,
between
it
the
is.
word
It's a-
I
action
mean, that it
and
is
the
a
word
windstorm,
claim
but it is a
because they
flood.
define claims to
Flood
include
instead.
claims,
Windstorm, I
actions,
mean, you can
and
look at the
causes of action,
definitions.
showing
Which
that they understand the
definitions are
difference.
Dictionary definition,
So
so
we
it what it may.
contend, with the
Everybody
support of
in the
Archer
dictionary
and
at least
other
understands
authorities,
that
that
hurricane
this
or
any action
windstorms are
clause is
associated with
unambiguous
wind,
and the
and they're
entire
associated with
lawsuit
rain
must
and
be
flooding
arbitrated.
and all those other
But that
things.
is at
You
least
kinda
a
know that from
reasonable
common sense
interpretation
perspective.
of the arbitration agreement.
So I would say,
And
if
so in
you're
that
gonna
case, the standard
look
for
to the
denying
law to
arbitration
find
is
out
not
what a
met
windstorm
because
is,
this court can have
you
no
can
positive
do that, but you
assurance
don't
that this
need to.
agreement is incapable
That's
of
not
being
our
read
argument.
to
Our
cover
argument is
this
the plain
action.
meaning. We bought a deductible buyback policy, windstorm.
I'd like to turn
You
now,
look at
unless
the
the court
policies,
has
you don't
questions about the
necessarily need
scope
to
of the
look at
arbitration
the law. You
clause,
can,
to
but you
appellee's
don't need
asserted
to. This is
defenses.
a very
Let me ask you
very
one question.
specific
When you say
question.
arbitration
In a
clause,
deductible buyback
the
policy
settlement
that's buying
agreement
back a
has two
certain
paragraphs
deductible,
discussing
what are we buying back?
arbitration. Are you
What do you
referring
do with our
to
court's,
B5C
with the
or
Pan Am
C4,
opinion?
or how
Yeah,
are we
so here's what's
supposed to
different.
interpret those
Here's how Pan
provisions
Am
together?
fits in with our case.
C4
Pan Am
is the
had the
clause
exact
that I'm
same
referring to.
master
And
policy.
Polyflo's position
And
is
the court
that,
looked at it
based
and
on the
said,
text and
well, are we
context
gonna
of the
apply
settlement agreement, that
windstorm, the big
C4
deductible,
is the
or the
arbitration
small
clause.
deductible, which was the exact same
B5C
number.
is
small
it's
deductible
essentially
was
belt and
for flood, that
suspenders.
was
It's additional
$50,000.
language that also
And in Pan Am, you
underscores
said,
the broad
let's
intent
look
of the
at what
parties to
policy says,
arbitrate
and you applied
a
what the
broad
policy
range
said.
of
And it was
disputes.
the
And so
exact
when I'm
same
referring to the
language as in
arbitration
our
agreement,
master
I'm referring to
policy. The
C4,
windstorm
but
includes-
B5C, as we've argued in
it
our brief,
includes
is
all these
further
things that you
support
associate
for
with the
the
windstorm,
argument that
rain,
there's no
hail,
positive assurance that the parties
tornadoes,
agreed to
wind gusts,
exclude
and
any of the
flooding.
claims in this action.
So what we did differently from Pan Am is we did the extra step.
Okay, thank
We
you.
didn't come to you saying,
I'll turn
oh my
now
gosh,
to
we think the
defenses.
small deductible should
This
apply.
court
We
should
did it
hold that the
differently. We
issues
went
of
and we bought
release,
coverage for that
prior material
deductible.
breach,
So we're
and
one
lack of
step
mediation
removed.
are
We're
for
one
the
step better.
arbitrator to decide.
We would say.
This
And that
court's
also
inquiry,
addressed,
when faced with a request for
I think the
arbitration,
point
is very limited.
We don't need
The
to
court
get
does not
into
address
these
the
cases
merits,
about
but asks
wind
only
damage versus
whether an
flood
arbitration
damage. And there's
agreement
a whole
exists
series of those
and whether
cases
the subject
in
matter
Texas
of the
and the Gulf
dispute
Coast
is within
region.
its scope.
We're not trying to disturb
Where the
any rulings
existence
that were
of the
entered in those
contract
cases.
is not at
And all of
issue,
those
as here,
cases, for example,
the only
Courtroom,
defenses a
it's
court
probably
may
the leading
consider are
Fifth
those
Circuit
that
case.
specifically
In
relate
Courtroom,
to
we
the
had a
making of the
State Farm
arbitration
homeowners
agreement
policy-
itself.
homeowners policy.
Defenses that
If you
apply
look at
to
that
the
policy, it
continuing
said-
enforcement
It
of
said
the
it covers the
contract
named
as a
peril,
whole
windstorm or
are
hail.
for the
But
arbitrator
in
to
that named
decide
peril
as part of the
definition for
merits of the
windstorm or hail,
underlying
what does it
dispute.
cover?
This
If you
court
look
has
at
held
the
that
policy,
repeatedly in
it's
Primerica,
defined so
in
that
Bank
does
One,
not
in
include
Will Drill,
loss caused by
and the
rain.
Supreme Court has held the same
In
in Prima
addition,
Paint.
there was also an exclusion
Here,
for flood.
appellee's
And that's the way
defenses
these
that
policies
Polyflow
work. They
has
put the
sued
exclusion
on
in,
released
and they
claims,
also
or
define
that
what the
Polyflow
named
has
peril is.
committed a prior
We didn't
material
have that
breach of the settlement agreement by firing the neutral
it's not
pipe
an issue of
expert.
whether
These are not
we,
independent
should have
attacks that solely
thought
relate to
something
the arbitration
differently about the
agreement, but they
policy,
are
because as
merits
you read the
defenses
two
that go
policies
to
together,
the enforcement
to
of
us
the
at least,
contract more
it's pretty
generally.
clear.
And appellee's answer illustrates that. Their answer in the district court, which this court can find at Record on
Now, I
Appeal
want to address this
1324
argument
to
about
1325,
named peril
and I
policies
direct the
don't
court
need
specifically to
exclusion.
paragraphs 3
Now,
and 15, make it clear that
example
they
I
have
guess,
pled both
let's
release
say you lived in
and
California
prior
and
material
bought
breach as
your
affirmative
house above an
defenses to
earthquake
Polyflow's
policy,
claims on the
and then a
merits,
tornado ripped through
as well as using
Sure,
both
perhaps.
release and prior
And
material
you
breach
make
in
a
the form
claim
of
under your
allegedly
earthquake policy,
firing
saying,
the
yeah,
neutral
but you
pipe
didn't include
expert
a tornado
as a basis
exclusion.
for their counterclaim
Well,
for breach
that's
of
an
contract.
example of where a named
So
peril policy
it's clear
does
from their
not
answer
need
that these
an
issues,
exclusion for
release and
tornadoes.
prior material
Our
breach,
situation
these are
is different.
merits issues
We
for
have
the
a
arbitrator
windstorm.
and not
And if you
defenses
look
to
at
the
where
making of the
windstorms
arbitration agreement for the court.
defined up for
Ms.
common
Stratton,
meaning,
so let
it
me
would
move back
naturally
to your
include
first
the
issue
wind
for a
portion
minute.
and the storm portion. So
There, you
look
know,
at that.
let's
And for
assume
how-
there's a
for a normal
textual
business
argument in
person,
the
what would you do to
arbitration
protect yourself?
clauses for
I don't care
looking
which side you're
at
on, but if you're
this,
an insurance company,
your
you would say, well, let's put the
complaint
exclusion in because
or looking
we have a
through your
windstorm and
causes of
flooding's
action or
associated with
whatever
that. We
on a
want to
piecemeal
exclude that. So
basis.
it was imperative
One
on
of
them to put
those
that exclusion
is
in the policy.
fraudulent
If you look at the
inducement to
policy,
settle.
the landmark
How do
policy,
you,
there's 5
how do you
exclusions in
square
there.
that
There's an
with
exclusion for pollution.
arbitrating the
there's an exclusion for
contract?
electronic
And
data,
also,
there's an
what
exclusion
about
for
the
fungus,
tortious
wet rot, dry rot,
interference
and
claim?
bacteria.
How does that
There's an exclusion
arise
for
out of
terrorism,
the
and there's an
settlement
exclusion for
agreement?
pathogenic,
So
or
I'll turn
poisonous,
first to the
biological,
fraudulent inducement claim.
logical,
It
or chemical
arises out of the
material.
settlement agreement for
terrorism
the
has
following
nothing to do
reasons.
with,
First, under
with the
Texas law,
hurricane, but
a fraudulent
at any rate,
inducement
they put
claim
these
cannot
exclusions in
exist
there.
but for
It's
the
imperative
fraudulently
that
induced
they make this
contract, and it
clear
requires
to
the
the person
existence
buying
of that
the policy
contract
that
as
they're-
part of its
if they
proof.
don't want to exclude
Our
flood,
claim
they
is
don't
even
keep it to
more
themselves, they keep it
dependent
to their
upon the
underwriter.
contract because
It's closed
in paragraph
cubicle.
80 of
They
our
let us
complaint,
know.
we allege
And they
that
didn't let
it
us
is
know. They didn't put it in the
misrepresentations in the
policy.
settlement
It's not
agreement
part of the
itself
policy
that
wording.
fraudulently induced us to enter the contract. And I'd also
I'd like to
direct
open
the
it up
court's
for any other
attention to the
questions.
following decisions: Prima Paint, Enri Kaplan from the Texas
Judge Willett,
Supreme
Judge
Court,
Engelhardt, do you have any further
Burwell from
questions
a
for
Texas
Mr. Miller?
Appellate Court, Sweet Dreams from the Seventh
Mr. Miller, I
Circuit,
think we
as well as
understand
this
your
court's own
argument,
decision
sir,
in
unless you have
Marlin,
anything further.
which involve broad
Yeah, let
and
me
narrow
address,
arbitration clauses. And
public
the courts
policy
held in
and also
all of
how
those
we're not,
cases that fraudulent inducement claims were
not
arbitrable, whether the
trying to
clause was
change any
broad
law
or
with
narrow.
respect to any of this case.
As
We
for the
realize
tortious
that there's a bunch of
interference
cases
claim, Your
out there
Honor,
that would be so
these
unfair.
claims are specifically
we're not trying
predicated
to-
on misrepresentations
trying
and
to address this
omissions
allocation
that we
issue.
allege appellees
What
made
if-
to
what
third
if wind
parties
damages
about the
property? What
settlement
if there's
agreement
wind blowing
itself.
rain? What if there's all this
These
stuff?
are these
Those are different
misrepresentations and
types of
omissions are
policies. They
pled
have
at
different-
paragraphs
they have
64
flood
and
exclusions,
68
also
of
define
our
what is
complaint.
covered. That's
And
an
they
issue
are
we don't need to
incorporated
get
by
into
reference
now.
into our causes
It's
of
an issue
action
that
at
they wanna
paragraph
drag us
70.
into. They wanna
And
have
you'll
us go
also
back to
find
the
them
district court and
incorporated by
litigate
reference
that
into the
issue.
tortious
But we don't
interference
need to
claim
do
at
that
paragraph
here.
117.
We're not altering.
And so
the
we
case
allege
law.
that the
As
breaches
public
of
pol-
duties
as far as
imposed by the
public
settlement
policy
agreement,
goes,
the use of our
a business
information,
owner in
the
any state, they
misrepresentation
should be
about
able
our
to rely on the
relationship
contract
is
as
what
written.
caused
If you
tortious
look at the
interference with
contract as
business
written, it's a
relationships.
deductible
And this court has made
buyback
clear in
policy.
numerous cases,
It
as
buys
have
back
Texas
that
courts,
deductible.
that
And you
a
look at
breach
what
of
deductible
contract
buys
can
back
involve
for,
tortious
it's a
conduct
2.5%
that gives rise to both
deductible.
breach of
It's
contract
not what we
and tort
thought,
claims at the
it's
same
what we
time.
got.
And that's
We
what's
got
happened
a
here. It's
policy
why our
that
tortious
refers to
interference claim
another
arises
policy,
out
the
of this
master
contract
policy, and it
because
buys
it
back
is
that
generated
deductible.
by
All this,
appellees'
I
alleged
call it
breaches
nonsense
of the
about
contract.
wind and whether it's wind or not, or whether
Do you have any
occurrence or whether it's,
idea
apparel.
why Judge
That's
Hoyt
stuff that doesn't
disposed of
matter.
this
It doesn't make any
in one
difference.
sentence?
This is
And
a
I'm
policy that
looking at the
defines what it
docket, it looks
covers,
as if there
and it
was
covers
no
the
oral
deductible,
hearing
buys back that
on
deductible.
the arbitration
Thank you.
agreement, so.
Thank you. We have your argument.
I do not know.
Mr. Brown, you
That's
saved
quite a
time for
mystery to
rebuttal.
us as well.
Yes, thank you.
Particularly given the
Some
strong
points
presumption
very
in favor of
quickly. First of
arbitration
all,
and the broad
The
language here
statement was
under
made
numerous
that
court
the
precedents.
landmark policy
So his
incorporates all the
summary
terms of the
denial of
Lexington
arbitration
policy.
is quite a
and that
mystery
is
to us,
not
and it's why we're
correct.
here.
In fact, in
I
the
don't know the
maintenance of
answer,
primary
unfortunately,
insurance
Judge.
clause, it has in
I
all
would like
caps,
to turn and
except
discuss
as
failure of
otherwise
mediation
provided
now.
herein. So it does not blanketly
Mediation
incorporate
is a
everything
question of
in the
procedural
Lexington
arbitrability.
policy.
And
It
procedural
says,
arbitrability
except
is a
as
question for
otherwise
the
provided
arbitrator
herein
in nearly all
caps.
circumstances. This
Secondly,
court has found that there's
the,
only one rare exception in which the
But you
court
understand that
can
this
decide a
is,
procedural prerequisite
certainly
bars
not
arbitration.
useful. If
And that is
thought
when it
was
is
going to just
clearly
be for the
established that a
deductible,
procedural
it's
requirement
not
is a
gonna
condition
because
precedent to
incongruous.
arbitration
They're not
and
the
has
same
been breached,
under your reading.
such that
So
no
it doesn't
rational
fit in
mind
what they
could
thought they
conclude
were getting.
otherwise. That high bar for taking this
Does it
question
matter?
of whether
I mean, you could say it
mediation is a
doesn't matter,
procedural bar to
but-
arbitration
I
has
don't mean to
not
be-
been
Yeah.
for taking that question from the
Parallel,
arbitrator
And
has
you're
not been
saying
done in
Actually-
this case.
that they're not.
Because a
Yeah.
rational mind
Actually,
would
that's,
agree with
there's no
Polyflow
there's
that
no evidence
mediation
of
is
that in
not
the
a
record.
condition
And I don't
precedent,
think it's true because
or
that's not
that
the
if
way
it
managed
is,
peril
it's been
policies
either
work.
deemed fulfilled
If they wanted
or
to have
excused
say,
by
if they wanted
appellee's
to have a
conduct
below
frustrating
deductible
mediation.
policy
And before I
that
tick through
included
those
all
reasons
the
very
risks
briefly,
that their main
I'd like to
policy
remind the
did,
court
then
that
that would
under
be an
General
all-risk
Warehouseman and other
policy.
precedents,
And guess
this
what?
court
It
doesn't
wouldn't
need
be
to
called
agree that
a below
polyflow
the
would
deductible
prevail on
policy.
any
It
of
would
these
just be
points.
called the
It need
primary
only
policy.
conclude that a
The
rational
purpose of
mind could agree and
Yeah.
that these issues
So,
are not
but let-
clearly
Policy not
established,
exclude
such
flood
that
damage
it's
the same way
the
it
arbitrator's
excluded
province to
terrorism and
decide
fungus.
whether
Oh, because
mediation
it
is a
doesn't
bar.
need to, according
Mediation
to
is
this
not a bar,
court's teaching
not
of
a
what a
condition
named
precedent
peril
because it's
policy
disfavored
is.
under Texas
And
law.
also,
And
if it
I'd note
included
that
an
it reached
exclusion for
page
flood
30 of their brief.
damage,
Appellees have
then
reversed
it
course from their
strips
position in
the
the district court, and they've argued
the
to this
very
court
identity of the policy
that mediation
away.
is in fact
Then why
not
did
a
it
condition
include an
precedent. That
exclusion for
seems
something
at least
else?
suggestive
Something
that
else.
a rational
It's
mind
easy
could
to
agree with
see
polyflow.
the terrorism is there as
The
a
settlement
result of
agreement's
the national
mediation
terrorism
terms
law.
only
It's in
apply to
every
issues of
policy
B1
now.
and B2 compliance.
It's easy to see why the data and
They
all
don't apply
that.
to the
What
other
they're saying
types
is,
of
look,
issues
even if
that
you
are in
have
dispute here.
something from a named
And even
peril,
as to
even
B1
if
and
you
B2,
have
they only apply when the pipe
windstorm
expert has
or
made a
hail,
determination
if it
that
comes
the
in and
appellees
it
are
ruins
out
your
of
data,
compliance,
we're not going to cover
which
that.
appellees
If
concede
it
never
comes in
happened
and
here.
it causes fungus,
But
we're
even
not
if it
gonna
is a
cover
condition
that.
precedent,
But
it's
you
been
don't have to,
deemed
so you
fulfilled
pull
by
that
their
out of
failure
those
to
perils.
specifically deny it
You
in their
had asked
answer.
earlier,
But even
Your Honor,
more importantly,
about
it's
definitions,
been
and I'd like to
frustrated
remind the
by
court that
appellees
of all the
withholding of their
definitions
design and
provided by
manufacturing
both
process
sides
information,
of
which is the
windstorm,
earlier step
no
necessary to even
definition
get to
contains
mediation.
the
And this
word
court has
flood.
held that a
None.
promisor cannot take
And
advantage
I'd
of a
also like to
condition,
look at this,
a failure of a condition that they
perils,
themselves frustrated.
covered,
And I
where
see
it
my time is
says
ending, so I will
windstorm or
reserve the
hail
remaining time for
associated
rebuttal.
with.
Thank you,
And my
ma'am.
point is, with
We'll
those
hear from
words,
Mr.
using common ordinary meaning that we're supposed to use, it is impossible
muted.
to tease out
There you go.
the concept of flood damage from that.
Thank you, Your Honor.
Not by using ordinary
May it
meaning.
please the court.
And those
my
are
name
the
is Steve
perils,
Slather, and I'm
whereas
representing the
named
appellees
storm
here.
is the occurrence or the
I think
event,
a brief
just like in the
background here
Pan
would
Am
be helpful
case.
to
And the
understand
perils,
kind
it
of the
says perils
context of
covered,
this settlement agreement.
windstorm or hail associated with the named
Mr.
storm.
Wright,
Now,
one
as
of
far as the different
defendants and
perils,
appellees,
the Josh Gibbs
is,
affidavit makes clear
was
that
the
there are
developer
different perils.
of the
And
technology
guess what?
that's kind of at
Windstorm or
the
hail are
center
usually
of
written
this.
together as one peril and for
He
one
founded
charge.
Polyflow.
That's
He was the
different than
CEO
fire
for a time,
or
developed
earthquake
its
or
products
flood.
during that
And that's
time.
apparent in the worksheet he uses
At some point,
that has
the
those
parties
perils
went their
lined up and
separate ways.
identified.
Mr. Wright
There's not a
set out
charge
to
for
form
windstorm
specialty
or different charge for hail.
RTP, where
There's
he
only
remains
one charge
today,
you can make for that
and
peril.
Polyflow
And that's the
continued
way
with its
carriers write
business.
policies. Because when you have a
You've seen
windstorm, it's
reference,
very
and
easy to say
we
that.
discussed it
I
in
mean,
our brief
that's
that
usually where
in
hail is
2015,
apparent.
Polyflow
Finally, in the
brought
Lexington
claims
policy,
against Mr.
it
Wright
has
and
3 deductibles under
SRTP,
windstorm or
and in
hail.
fact, those
And the first
claims
one
are
is just for windstorm or
largely
hail.
the same
The
claims they bring
second
now
2
in this case.
bring in and include the concept of named storm that has all
That
this
suit was
flooding and
ultimately
other
resolved.
stuff.
It was,
So
it
why
was,
would it have?
Well, you need to wrap it
really
up.
best described as the
Well,
nuisance
my only
suit,
point is,
and that's
if
evidenced by the fact that
SCD's argument
if
is
you look at the
correct,
settlement agreement, no
why
money
would the
changed
Lexington
hands there.
policy have
The
3 different
part of that
deductible
agreement
schemes
is sections
if in
B1
fact
and B2, and those put
windstorm always
restrictions
brings
on
into account flood and
specialty
the things from a
RTP
named
with
storm?
regard to
Because they're very
what
different in this
information it can
deductible
use and what products
allocation
it could
provisions,
design
and the peril
or
allocation
manufacture.
provisions of the deductible.
We have
Just
your
as
Mr. Wright and
argument, sir. Thank you
SRTP have
very
never
much.
used
We appreciate
Polyflow
it.
information, but the
This
agreement
case is
provided
submitted.
that there was a
We
mechanism
appreciate you
for
appearing today,
Polyflow to confirm
virtually,
on an ongoing
and we look
basis
forward to
whether
continuing to consider
any
your
of
case. Thank you.
SRTP's product did include Polyflow information. Of particular importance to specialty RTP was the dispute resolution framework set forth in sections B4 and B5 of the agreement. And what those call for is the appointment by an arbitrator of what's referred to as an RTP expert or a neutral pipe expert. And that was a person that was neutral and also knowledgeable about the technology and the products that were involved from both Polyflow and SRTP. And that framework requires that the pipe expert examine any products that specialty RTP intended to manufacture or design for a time period and make a determination of whether those products violated section B1 or B2 of the settlement agreement. And the reason this framework was set up this way and the reason that there was a neutral expert put in place was because specialty RTP was particularly concerned that Polyflow would use this mechanism to discover or learn about specialty RTP's technology. And so that's why they had this neutral expert in between, so that neither party's proprietary information would ever be shared with the other. It would all go to the neutral expert. He would make a decision, and the information would remain separate from the other party. Going forward, the pipe expert, once he made a decision, and as Ms. Stratton noted, if the decision was in favor of specialty RTP, the pipe expert's decision was final. Only if he found that specialty RTP was in violation would it then trigger a mediation process, and the pipe expert would attempt to mediate that dispute. And only if he was unsuccessful in mediating that dispute did the parties then agree to take that dispute to arbitration. And that is the arbitration provision that you see in section B5 of the agreement. And it is specifically related to these disputes that may arise in the context of the neutral pipe expert and sections B1 and B2 of the agreement. But the important part of that is that the purpose was to prevent specialty RTP's technology from falling into Polyflow's hands under the guise of policing the agreement. The second arbitration clause here is found in section C4. It relates only to disputes that arise under the agreement. And that's very clear. The court, and I think on that point, the courts are clear, including in the Pennzoil case, that an arbitration clause that uses language such as arising out of is a narrow clause. And the court in Pennzoil contrasted that with broad clauses that use language such as arising out of or related to. That's clearly not what we have here. Under Pennzoil, the clause in C4 is a narrow one. That's further evidenced by the fact that the clause in C4 does not even cover all disputes that would arise under this agreement, because it's, as I mentioned, the separate dispute resolution mechanism set forth in section B5 would cover disputes that fall under sections B1 or B2 of the agreement.
Well, I might agree with you if the arbitration provision in B5C said anything about limited to this agreement or this mechanism, but instead it says, for purposes of clarity, the parties are agreeing that any disputes arising out of or related to this agreement will be arbitrated. And aren't we, since and going a little further, aren't we required to interpret these provisions harmoniously and not one limiting the other or being limited arbitrarily as opposed to the other one? Go ahead.
Well, I think they do need to be interpreted harmoniously. I'm sorry, Your Honor. I think they do need to be interpreted harmoniously, and I think the way that that is done in this case is that you look at the agreement as a whole, and specifically in sections B4 and B5, it sets forth this dispute resolution framework that relates to as I mentioned, the neutral pipe expert and his duties to resolve disputes arising under sections B1 and B2. And then if you look, C4 then would cover anything else. And so otherwise you would, if you read section B5C broadly to cover all disputes that arise under or relate to the agreement, you end up rendering the clause in C4 a nullity. And that's what the parties intended here was that agreement or that clause in B5 would relate to the dispute resolution framework of sections B1 and B2. and that C4 then would cover any other disputes that arise under the agreement.
Well,
So with regard to,
what's your best case? What's your best case?
with regard to,
Yeah, you and I, your transmission is a little slow. I'm sorry, I don't mean to interrupt you.
I apologize, and I don't, it does drop occasionally, and I'm not sure why.
Well,
I think just the plain reading of the agreement, as you mentioned, requires those two clauses to be harmonized, and the agreement itself makes clear how to do that, because it sets forth the framework for dispute resolution under B1 and B2 in sections B4 and B5. As I mentioned, where you have two competing clauses, and in this case they don't compete. But if you did try to read them on top of each other, one would just be rendered a nullity, and that shouldn't be the right result here. Further, I believe I understood Polyflow to say that they are seeking arbitration solely under C4 in this case. With regard to the argument that all claims, if any claim is arbitrable, all claims are arbitrable, and that's Polyflow's argument with the Archer case. Here again, the agreement makes clear that certain disputes, those arising under B1 and B2, do not fall under the arbitration clause in C4. And so at least one category of claims would not go to arbitration, even under that, or should not go to arbitration under Section C4. That's not what the parties agreed to. They agreed to have two separate arbitration provisions covering different aspects of the agreement.
so is it your position that you want part of this dispute arbitrated and part of it submitted to the federal court?
Well, we believe all the claims should properly remain in front of the court, and that none of them are arbitrable. And
Well, you just said that B1 and B2 are arbitrable.
They are if, and that goes to whether certain conditions are met. And as we describe in our briefing, those conditions just simply haven't been met. There's a framework, and it requires the appointment of an MPE by an arbitrator. That was done. And it requires the pipe expert to then examine SRTP products to see if they are in violation of sections B1 or B2. He's done that. In this case, he has not found a violation, and therefore, under the terms of the agreement, that's the end of that inquiry. However, if there was a case where he found SRTP to be in violation, only then, if he was not able to mediate that dispute, would that specific dispute go to arbitration under the provision in section B5.
Well, I mean, they assert that a number of their claims, they assert
in that way, then.
Okay, I'll try again. They assert that a number of their claims are based on disclosures of information contrary by specialty RTP, contrary to the settlement agreement, interference with customers of Polyflow, and Lanham Act violations, And it seems to me all of those are reasonably read as being governed by the settlement agreement. So why are they not arbitrable under C4?
Well, if we look at the Ford case, for example, the test for whether tort claims arise or relate to the agreement is whether those claims could stand alone. And so certainly the Lanham Act claims, which relate to trademark trade dress largely, those claims could certainly stand alone here. The existence of the agreement is not required to go forward with those claims. With regard to tortious interference, it's the same. The activities that Polyflow complains about which was disclosing information to certain customers, setting aside that may not even fall under the Lanham Act because it doesn't relate to goods or services. That cause of action would stand alone. It does not require the existence of the contract. And the same is true with regard to the fraudulent inducement claims. And that's, if we look at the Ford case, it addressed fraudulent inducement, Lanham Act claims, and tortious interference claims. And in each of those instances, it found that they did not relate to the underlying agreement and did not require the agreement. And in that way, they stood alone and were not arbitrable. And I will point out in that case that was a broad that did involve a broad arbitration provision that covered any claims arising from or related to the agreement, which is not what we have here. We have a narrow provision that only covers claims that arise from the agreement. And so, with regard to Lanham Act, fraudulent inducement, tortious interference, they simply just don't arise from the agreement. They stand alone under Ford.
Why is it that your client decided not to do arbitration?
Polyflow has asserted in this case a number of claims that it previously released in the earlier case. And we've provided a comparison of those claims, and you'll see that they are, most of them are largely identical. And in fact, in the first amended complaint, Polyflow makes clear that it's relying on activity that occurred before the settlement agreement, and that's at record 1203 and 1204. Where it specifically sets out before the settlement agreement, and then provides a kind of laundry list of bad acts that it claims SRTP is guilty of. Further, in the counts themselves, it refers to activity involving Exxon, Petronas. Both of those companies were part of the 2015 lawsuit. And so we don't want a case, and we think they should they should be resolved in federal court, not in front of an arbitrator. They simply do not arise out of this agreement. I mean, if we look at what the parties agreed to arbitrate, and that's really the focus here, what did the parties agree to arbitrate? It's very clear. They agreed to arbitrate only those disputes that arise out of the agreement.
And that's so, the word is action.
The word is action, and in this case, we contend that action means a claim or a cause of action. And we have addressed the Archer case in our response to Polyflow's supplemental authority, and that's further underscored by the party's definition of a claim in this case, where it defines claim synonymous with action, where the parties wanted to refer to an entire litigation they did so. For instance, they referred to the 2015 litigation, or they referred to it as a civil action. In this case, action should be construed to mean cause of action, and that's further underscored by the fact that to read action as the entire action in C4 would then render any claims that arise under B1 and are required to be arbitrated, perhaps at some point under Section B5, it would render that a nullity, and that shouldn't be the result here. Going back to two issues, with regard to the release claims, I understood Polyflow to argue that is an issue for the arbitrator. It's simply not. In this case, those claims, the released claims that are now included in Polyflow's current complaint were released in the same agreement that the arbitration clauses are found. And so that is not, those claims are not something that the parties agreed to mediate. It perhaps could be a different result if the release claims were in a different agreement or something along those lines. But here they were released in the very same agreement. So it makes no sense that the parties would have agreed to release those claims, but still agreed to arbitrate them at some point in the future. With regard to the failure to mediate, the framework in Section B is very clear that if Polyflow believes that SRTP is in violation, it can raise that issue with the neutral pipe expert, and then he will go forward with his analysis and mediation if necessary to resolve the dispute. SRTP has complied with every request from the pipe expert with regard to providing products. So for examination, products and information. So to the extent that Polyflow claims that there are products that it believes are in violation, but SRTP has not turned over, that is the result of Polyflow not raising that issue with the neutral pipe expert in the first instance. And I see I am out of time.
Yes, sir, you're out of time. We'll go back to Ms. Stratton for rebuttal.
Thank you, Your Honor. I'd like to begin with the issue of mediation. You've heard opposing counsel describe their view of why mediation was a prerequisite here, and we obviously vehemently dispute that. And that's precisely why the issue is not clearly established such that this court could decide it, because no rational mind could do anything but agree with Mr. Schlather's position. He's not articulated why it is clearly established and essentially undisputed here that a procedural prerequisite was breached. So all of his arguments about what should have been done in the mediation process, that's all for the arbitrator to decide under this court's procedural arbitrability precedents. I'd like to also briefly discuss the issue of release. Appellees appear to be trying to take the issue of release and frame it as a question of what the parties agreed to arbitrate, a question of substantive arbitrability. But this court has made clear that it does not consider the merits in its substantive arbitrability determination. You said that in Chevron Chemical, you said it in Bank One v. Hill, and in numerous other cases. And what Mr. Schlather's argument does by asserting release as a question of the scope of the arbitration agreement is inject the merits into the substantive arbitrability determination. For this court to decide whether Polyflow released or sued on released claims, it would have to resolve the merit. That is a basis for Polyflow's counterclaim in this case. That's not properly before the court in a substantive arbitrability analysis. Release is a defense. That's how this court should treat it. And that's exactly how Mr. Schlather's answer on behalf of Specialty RTP in the district court treated it as an affirmative defense on the merits, a basis for their merits counterclaim, and therefore it's properly submitted to the arbitrator as part of the underlying merits of the dispute. Now, I'd like to move on to addressing the interaction between C4 and B5. There is a way to harmonize these provisions, to read them quite naturally in a way that doesn't treat them as two separate arbitration provisions or treat them as a limitation on one another. First, there is nothing in the text of either C4 or B5C that suggests that they apply to anything other than the entirety of the agreement. There is no limiting language, as Judge Jones noted. And the most natural reading we submit of B5 is that it is inserted to protect the breadth of the parties' arbitration agreement, because it appears in a section laying out certain procedures for resolving certain types of disputes under the agreement. And it heads off the potential argument that by laying out those procedures, these were the only substantive claims the parties intended to arbitrate. And so the text of B5 says very clearly, for purposes of clarity, we are clarifying that we are agreeing that any dispute arising out of or related to this agreement shall be arbitrated. And so in C4, you have an extraordinarily broad arbitration provision. In B5C, you have another extraordinarily broad arbitration provision, and broad plus broad equals broad. It does not, as Mr. Schlather contends, equal narrow, and it does not equal arising under, which is what he said at the beginning of the argument, that we agreed in C4 to arbitrate arising under. This court made clear in Explo that arising out of and arising under are not the same, and that arising out of is a broader arbitration clause than the more narrow arising under. It's Mr. Schlather's burden to furnish this court with positive assurance that this arbitration agreement cannot be read to cover this action. And in order to meet that burden, appellees have had to rewrite the arbitration language to arising under and call arbitration clauses that this court and others have repeatedly called broad narrow, insisting upon that. And our opinion, Your Honors, is that that doesn't amount to positive assurance that these claims are not arbitrable. I'd also like to briefly distinguish Ford, which Mr. Schlather relies upon. In Ford, the court made it clear that when a tort claim is based upon a breach of contract, it's arbitrable. There was no breach of contract claim in the case. The parties could have completely complied with their obligations under the contract, and the tort claim in that case would still have proceeded. That's why the Ford court was able to say, this contract is legally irrelevant to this tort claim. We can treat it like it doesn't exist. That's not possible here. For example, Mr. Schlather asserts that the Lndmrk claims have nothing to do with the settlement agreement, but I'd refer the court to paragraphs 96 and 114 of our unfair competition claims, which are based specifically upon appellees' misrepresentations about the terms and scope of the settlement agreement itself. The fact finder simply could not resolve those claims without consulting the terms and scope of the settlement agreement, and they arise out of the contract. Thank you.
All right, thank you very much. That concludes our brief hearing for today, and we'll take the case under advisement.
Thank you.